In addition to multiple achievements in ECCE and the Mrs. Shopi's leadership, the Seychelles Institute of Early Childhood Development has been recognized and designated as a best practice hub for ECCE by the International Bureau of Education of the UNESCO in February 2017. Well done, Mr. Shopi. Please let's applaud you. Thank you very much. Now, no ECCE system is complete without a binding legal framework. The next speaker has been here so many times, and she might as well be a local, a true friend of Seychelles. She holds a PhD in education. She's currently the director of the UNESCO International Bureau of Education, a post that she's been holding since July 2014. Within UNESCO, she has had several director positions, including the director for basic to higher education and learning. Prior to UNESCO, her vast working experience includes the World Bank, university teaching, academic networks, consultancy services to governments and private companies alike. Given her vast experience in leadership positions in big global organizations, who else then is most suited to relate to us the impact of legislation on ECCE services? Ladies and gentlemen, let's welcome Dr. Mmantsetsa Marope.
Thank you very much, Chairperson, honorable ministers, and all the dignitaries here. Let me start this by announcing that I'm actually not the presenter for this session. I'm a gap filler because my colleague, Dr. Rola Moon, who is the lawyer of the UNESCO education sector, couldn't make it. But I believe that I hope I will not embarrass her, and if I embarrass her, you can excuse me. Rola and I have worked on the monitoring of the legal instruments of the UN as they relate to education for half a decade before I transferred to Geneva. Madam Shopi gave us an overview of the institutional framework, which in our estimation is probably the most defining pillar for an effective ECCE system. Because if you don't have an institutional framework to manage the system, it's going to be very difficult, as she put it, for the system to work systemically. And as we all know, most of what are called ECCE systems are actually ECCE service delivery, but they are very fragmented elements of service delivery. So I would just want to reiterate that having a system that holds, an institutional structure is probably the most important prerequisite for building an ECCE system. But once the system is in place, you have to regulate it, you have to manage it, you have to oversee it, which is mainly the role of government. Because when it comes to service delivery, ECCE has multiple service deliveries from many, many sectors. But the regulatory framework lies with the government, and it cannot lie anywhere else, unlike other elements of the ECCE. And I'm going to give an overview of the regulatory framework or the legal framework of ECCE. It comes at a global, at a national, at a sectoral, and at an ECCE level. And part of this conference is for us to interrogate our ECCE service delivery and ask if each pillar works, or where should we be strengthening each of the pillars that we believe are important for ECCE services to be delivered effectively and impactfully. So I'm going to start at the level at which I also work, which is the global level. the ECCE legal instruments, I'm not going to go into the statement of each instrument because there are too many and I would certainly pass my time. But it's important to note that many of your countries, probably all of your countries, are signatories to global legal instruments that underpin the delivery of ECCE. So you already have obligated yourselves that you will oblige the requirement of those global legal frameworks. And I'm going to take them in chronological order and the ones that are most pertinent to ECCE. And the first one is the 1924 Declaration on the Rights of the Child, sometimes called the Geneva Declaration. This declaration, to me, the anchor of it is the first statement that each and every child must be availed the means and the requisite means for its normal development, both materially and spiritually. So you could then unpack what is that development of the child. When we ask the question, what is that development of the child, then we are going to get into all the levels, their health, their nutrition, their emotional stability, and on and on. But development, this summarizes everything. And then it refers to children should not be hungry. If they are under distress, they must receive relief. Children must be in a place where they can have a means of a livelihood normally offered by their parents initially, and they should not be exploited. They should be protected from any form of exploitation. It goes on and on. I'm not going to read each because you can read at your own leisure and you can read the original instrument yourself. And then in 1948, we have the Universal Declaration of Human Rights. The whole declaration applies to children because this applies to human rights and children hold the rights. And I am not going to go into everything, but that each person is born free and is equal in dignity and rights. This declaration speaks to inequity of service delivery to children of an early age. If we say everybody is born free and has the dignity and equal rights, then every child deserves and has the right to have equity of services that they require to holistically develop. And then it refers to motherhood and childhood, that they are entitled to special care and special assistance. And all children, whether born in and out of wedlock, shall enjoy the same social protection. So all elements, if you look at the universal declarations, you'll find they cover practically all elements of ECCE. In 56, we have the International Covenant on Economic and Social and Cultural Rights. And I've put in bracket each article that has specific reference to kids. But if you look at these declarations, for as long as our point of departure is that children are human beings, any other declaration that is intended to protect and afford us a chance to develop, a priori covers children. So this is important. We have the Declaration of the Rights of the Child. I like this one because it talks about men, not womankind. But it says mankind owes to the child the best it has to give, the best that we have to give, we owe to the kids, including education. The question is, do we really oblige these declarations which we have signed? Do we give, do we afford, do we feel that we owe children in our respective countries the best that we have to give? I don't know. The 1973 ILO Convention is particularly important because it protects children from child labor and all forms of potential economic exploitations. So anytime a child is exploited, whoever is exploiting that child can actually be taken to task with a legal instrument that the country has saved. The 1989 Convention on the Rights of the Child, the CRC, is perhaps a watershed convention because it is the first convention that the other conventions talk about children and human beings. This convention specifically recognizes a child as a right holder. The conventions and declarations before the 1989 ones protect the child and talk about many things about children. And until hearing most ECCE zealots would say that until the 1989 convention, children were seen more or less as properties of their parents or properties of some adult, and that some adult will exercise the right on behalf of the child, and therefore the child is like a proxy beneficiary of that authority who exercises the right. But this convention says the child is a right holder, which means that our children can sue us once they get to an age where they understand they held the right at birth. So this is a particularly important convention that I must highlight. There's all the details about the ILO convention, so I won't go into. When Madam Shopi was presenting, she mentioned that mostly we have nice policies, nice laws, nice whatever, but we often falter when it comes to implementation. Now, the issue is not that we don't have, actually, the last time I was in Sydney in November on their 70th anniversary, they were celebrating the human rights, the Universal Human Rights Declaration. And I went through these legal instruments again. There are overall about 30 legal instruments that accord some right to a child. So if you wanted to take the whole network, it's quite expensive, but what I did here is just pick the most important few. Now, a lot of countries have signed this. We have the statistics. I just didn't want to bother you with such details. But the issue is how many countries actually comply, first of all, and they have the structures to ensure compliance, and they have processes to verify if there is compliance. This is really where the issue lies. It's not in the fact that some head of state or some minister went somewhere and signed on behalf of the country. It's after the signature, then what? I can talk about the UNESCO process because when I was at headquarters, I also serviced the CR, the Committee on Conventions and Recommendations. And let me also make a distinction between declarations and conventions, because these two global instruments are legally binding. Recommendations, on the other hand, are morally binding. So you can't quite take a country to task on the basis of recommendations, but you can diplomatically shame it, if there is diplomatic shaming. But because member states have signed these recommendations, hopefully they mean something. Now, for UNESCO, the CR, our Committee on Conventions and Recommendations, it meets half yearly. And my job was to monitor compliance by the countries. The countries, every 5 years, we have what we call a consultative process. And this consultative process entails checking compliance of all the recommendations, the conventions and the declarations pertaining to education, some pertain to teachers, some pertain to children, some pertain to students and all that, and I would report to this committee on the level of compliance. And I can tell you that, there is there is a bit of a gap between the signing and giving effect to those legal instruments. A legal instrument is a piece of paper. That's all it is, with lots of signatures. Until it's obliged, it's when it's given effect that we can get the benefit of its impact. So I would want to ask all the countries represented here, since you signed these instruments, do you have structures to check, to ensure compliance? Do you have processes to track your compliance? And when there are infractions, what do you do? When you know that you didn't oblige, what do you do? It's a bit of a tricky situation because you are asking governments here to be excuse my language, to be the police and the thief. But if the thief said, I want to police myself, hopefully this will happen. That was off the record for anybody who is recording. Okay. It's important to highlight that there have been several instances where these infractions are reported to the CR, and from UNESCO's point of view, these are dealt with in a very serious, respectful, but very rigorous and robust manner. The challenge is for the countries and all the political leadership in this room. The challenge is, do you have that robust, sober, serious, respectful, but very rigorous manner of ensuring your compliance? Or do we just sign? Below the legal instruments, we have the IAGs, the internationally agreed goals. I would put these more or less on the same level as recommendations, because the fact that you signed on the Millennium Development Goals or EFA goals or the SDGs does not mean that you are legally bound, but by signing that, these instruments have another moral force that enforces whatever we said we were going to do, because these AIGs communicate a spirit of collaborating around a commonly and jointly set agenda by the global community. And different AIGs have given different level of impetus for ECCE. If you look at the EFA movement, which preceded many in Jomtien, the EFA movement had very loosely implied ECCE, but you don't actually read explicitly, except just the expansion of early childhood care and development, especially for the poor. But later on in Dakar, when we went to the midterm review of the EFA agenda, actually we skipped here Amman, because in '96 we were in Amman to evaluate what we thought would be the halfway mark for the EFA decade, because it was supposed to end in 2000 originally. So in Amman we had the midterm review. And then towards the end in 2000, when we hadn't met most of the EFA intentions, we then had the Dakar framework, which extended the EFA, what was originally a decade, into a decade and a half until Enchion in 2015. But if you look at the Dakar framework, the first goal, the Dakar framework was tighter than the Jomtien framework, and the first goal pertains to ECCE. There are other goals that imply ECCE, But if you look at all the evaluations by the UN system and the Bretton Woods Institute and all the international organizations, the EFA Goal 1 is referred to more. Then we had, after the EFA agenda, we have the MDGs. And if you look at MDGs, Goal 2, Goal 4, 5, and 6, they refer to some aspect of ECCE. And then in 2010, and that was, half a decade before the end of the extended EFA period, we had the Moscow framework. I must say I'm a little proud of this framework because in it, it defined ECCE more explicitly, that ECCE covers ages 0 to 8. So it overlaps with early primary education, but it starts when people are planning to fall pregnant, not when a child is born. That's when ECCE starts. And in Moscow, UNESCO very clearly and crisply conceptualized what we mean by ECCE. This was adopted as the global conceptualization of ECCE, and that's what we follow now. It recognized the Moscow framework, the holistic nature of ECCE, its integrated nature, the multisectorality, and that it covers all these elements that I hinted on. And then in Enchion, because at the end of the EFA agenda, even after the reinforcement from Moscow, we still were globally, underperforming in ECCE. So in 2015, when we were crafting the SDG for education, you'll realize my bias, start with education. We did also explicitly reinforced ECCE as an inescapable enabler. We wanted to use a stronger language, an inescapable enabler for realizing equity, quality of education and lifelong learning for all. But the SDGs, many SDGs, have some implication about ECCE and all of these, whether it's about poverty, hunger, about health and well-being. All these SDGs which you have signed oblige you to deliver some aspect of ECCE. Actually, the SDGs as a framework are far much stronger on ECCE than were the MDGs. But I guess we learn as we go. This is a continuation of the SDGs, You realize the ones about education, about water, about economic growth, decent work, all these explicitly speak to ECCE. We had a few examples of countries that followed some of these, but I'm going to skip them and get to the national legal instrument. So at the national level, I am certain that your constitutions say something about human rights. And I'm certain that your constitution says something about the rights of a child, and I'm certain that the Constitution says something about the protection of a child, multiple protection, social protection, economic protection, emotional protection. So if you could ignore the global instruments, you would not escape that then at your own national level, you did obligate yourselves legally, because the Constitution is the highest law in the land, that you will provide for ECCE services. I would encourage you to familiarize yourselves, because people just don't read their constitutions. It's important to know your constitution if you are a Christian, like a Bible, if you are a Muslim, like the Quran. Because the constitution is the Bible or the Quran of the country. And people don't read constitutions. So even when their constitutions afford them certain protections privileges and immunities. They just don't know. And normally when you don't know your rights, when they get violated, you don't know what to fall back on legally. So know the legal leg. But the question here is, as you are strengthening your ECCE regulatory framework, is it anchored in the global instruments and is it anchored in the national constitution? Do you deliberately say, our constitution says this, and because our constitution says this, this is how we are going to give effect to the spirit and letter of this constitution? At the lower level than the constitution, you have sectoral acts. You have Education Act, Health Act, I don't know, Economic Act. There are lots of acts. And I'm certain that these acts will also say something. The Health Act will say something about children, about expectant mothers, about nutrition, about protection from all sorts of diseases and so on and so forth. When you look at your legal framework for ECCE, do you look at these acts? The Education Act will have a lot to say about children. I would be surprised if you look at any sectoral act and you couldn't find any reference directly or by implication to children. And therefore, as we implement our ECCE, are we obliging our constitution and our sectoral acts? Below the sectoral acts, we have the ECCE specific instrument. When Madam Shopi was presenting, she kept saying, this is a legal entity, this is a legal entity. But the system itself will have its own laws, its own regulations, its own procedures, right down to procedural laws. How do you register? How do you deregister a provider? How do you license? What are the obligations? What are the health standards of an ECCE provider, and so on and so forth? So essentially, this is the end of my presentation. The rest, as I said, are lots of country examples that we don't really need to delve into. What I want to suggest is that following the institutional framework, we have to be sure that our ECCE systems are legally anchored. They are underpinned by a solid legal framework. And since we are all local and global, we have to look at the global legal instruments right down to the instruments that are specific to ECCE in your particular local context. For decentralized systems, so South Africa, for instance, which is a federal country, you would have the national system, the national legal law system. You will also have the provincial laws, and then you can go down to the districts until the very last unit. This is important for those who are trying to strengthen your ECCE services, and for us, together with Honorable Minister Semeo and Madam Shopi, we really want to be sure that at the end of this conference, each one of you can consider your ECC as a building that stands on some pillars. And some of these pillars, you recognize they are rattling. And if you have a house that is standing on pillars that cannot evenly bear the load, the whole house is going to come down. That's the beauty of a system. If your nail aches, it just might deprive you good sleep. It doesn't matter that it's one little quasi-bone at the end of your finger. The system coheres because each and every pillar is load-bearing and the system is balanced. And we shouldn't have either the institutional structure that manages our ECC or the legal frameworks that underpin our ECCE cause that building to collapse. Thank you very much.